Hi guys, this is Erica from Gokce Capital.
Now before I begin, be sure to subscribe to our YouTube channel and turn on notifications. In 1826, a case came before Joseph Story, the sitting judge in the United States Circuit Court for the District of Rhode Island. This case, which would later define a large portion of U.S. water law, involved warring mill owners and a trench. The mills in question were located along the Blackstone River. Each of the mills used this river to power their operations and had more or less coexisted for years. But then, a few of the mill owners built a dam to divert some of the water from the river. Immediately, the downstream mill owners sued, complaining that the dam had slowed the flow of water to their mills, causing injury to their businesses. Thus was the case brought before Joseph Story. So who had the greater right to the water, the upstream or downstream mill owners? I'll let you know at the end of this video. But this sort of question is exactly what the riparian rights system tries to handle and resolve. And if you have never heard of riparian rights before, you should watch this video, because if you are looking at purchasing waterfront property, you likely want to understand the legal doctrine that dictates who has the right to use the water. So in today's video, we'll cover the top things you should know about riparian water rights. Number 1. Under a riparian water rights system, waterfront property owners have the right to make reasonable use of the water that flows through or next to their property. Now, it's important to note that the water itself is publicly owned in most cases, but the riparian rights holder will have certain rights, such as the right to keep the water flowing onto the land in its natural quantity and quality, the right to protect their property from flooding and erosion, with the caveat that any construction designed to prevent flooding and erosion must typically receive approval by local building agencies, the right to fish in the watercourse, the right to accretion. Now, accretion is when silt deposited by the river expands the riverbank. So the right to accretion means that the waterfront property owner effectively owns any of this newly created land. And the right to boomage, or the right to charge a fee for the right to place a boom in order to store logs. This was historically used by logging companies when they used to transport logs via river. Number 2, a use is considered reasonable if it doesn't interfere with the use of another riparian rights holder. What this means in practice can vary from jurisdiction to jurisdiction, but generally, water cannot be transferred out of the watershed in large quantities, and in situations where water becomes limited, then it is generally allocated in a fixed proportion among owners of waterfront property. But to understand exactly what reasonable means in your context, it's a good idea to speak with a local real estate attorney who understands water law. Number 3, the riparian water rights system usually applies to surface and groundwater in states to the east of the Mississippi. In western states, the prior appropriation rights doctrine, or hybrid system, is typically used. And again, you'll want to speak with a local attorney to understand the nuts and bolts of water law, both as it applies to surface and groundwater in your particular area. Number 4, a property owner generally has riparian water rights if their property borders a body of water or water flows through it. Above all, what's most important is that the property actually touches the water. So if your property is simply near a water source, you likely won't have riparian rights. But if you're looking at purchasing property, it's a good idea to speak with your real estate attorney and title company to verify what kind of rights come with the land. Number 5. Now, if you are not a property owner, but you have a local river or stream that you love to use for fishing, swimming, or boating, you may be wondering how riparian rights affect your ability to access the water. Well, as I mentioned earlier, the water itself is typically publicly owned. And in recent years, many states have passed legislation aimed at riparian owners, designed to encourage these owners to allow public access to the water. Primarily, these laws eliminate the liability that owners may face for allowing the public to use their land to access the water. But again, the laws vary from jurisdiction to jurisdiction, so you may want to speak with a local attorney to understand the legal context in your area. Number 6. Riparian rights holders generally have the right to build a dock or pier out into the water. However, most rivers and streams are ultimately owned by the state, and thus the states have the ability to veto a project if the dock or pier is obtrusive to the navigability of the water, or if the structure intrudes on another landowner's ability to build. So before planning your dock or pier, it's a good idea to check with the relevant state agency, often the Department of Environmental Protection or similar agency. Number 7. If you feel your riparian rights are being violated, you can file an injunction. The injunction will restore your rights, and if the violation has severely diminished the value of your riparian rights, then compensatory damages can be awarded. But, as with anything pertaining to a legal action, you should speak with a local attorney to verify how the process would work and whether you have a reasonable case. But let's return to the mill owners of Blackstone River. Let's take a look at a diagram of the mills from a senior college lecture, and I'll include a link to the overall PowerPoint in this video. As you can see here, a few of the mill owners created a new dam on the Blackstone River to divert some of the river flow into Sargent's Trench. Now it's important to note that up until this point, U.S. water law held that any landowner on the bank of a river had the right to use the water flowing through it, essentially as they saw fit. But Joseph Story upended this idea. He decided that a bit of equity had to be injected into the system, and ruled that upstream mill owners could only make reasonable use of the river. They could use the amount of water that they had typically received for the past 20 years, but could not divert so much water that downstream mill owners would see their enjoyment of the river diminished. Thus was born the modern notion of riparian rights. Although I'm sure most of you haven't heard of this case, any of us who use a river in the eastern U.S. should be grateful for it. For Tyler versus Wilkinson ensures that water remains a public resource, available to all, fisherman and kayaker, swimmer and mill owner. Now, do you have any stories about riparian rights? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down properties at gokcecapital.com/listings. Finally, don't hesitate to reach out with any questions. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.